All right, thank you. Mr. Fear, would you like to reserve any time?
Yes, if I could reserve 5 minutes for rebuttal.
All right, please begin.
Okay. May it please the court, my name is Peter Fear. I represent the appellant, Stephen Sloane, who's the debtor in the underlying bankruptcy case. Section 506B is clear that a secured creditor is only entitled to post-petition, pre-confirmation interest if the value of the creditor's collateral is greater than the amount owed to the creditor. In this case, appellee Stanton foreclosed on the collateral post-petition, buying the properties for credit bids totaling approximately $30 million and leaving debtor owing a substantial deficiency. Sloane contends the deficiency is approximately $27 million, and Stanton contends that it's approximately $40 million. However, based on a stipulation whereby Stanton was granted stay relief that recited the amount owing on the note as of the date of the stipulation, Stanton contends, and the lower court agreed, that Stanton is entitled to post-petition interest. And Stanton continued to charge interest right up until the dates of the foreclosures, which were held on April 27th and 29th, 2021. All right.
But wasn't that authorized by your stipulation? Your stipulation specifically provided that interest would accrue at about $31,000 a day, or there was provision for the accrual of interest. You agreed that they were oversecured, and it was your position on relief from stay that the property was worth quite a bit more than the debt. So you came to an agreement.
So, Your Honor, I don't think that we agreed that the property was oversecured. And I guess there's a couple of different ways that you could interpret what the stipulation actually says regarding the amount of the debt. One way is that it was just a recitation of the amount that was owing on the note based on the underlying note without taking into account Section 506B. That, I think, is actually a better interpretation of the stipulation because it doesn't say anything specifically about Section 506B. The other way to interpret it is that it is making a determination under 506B, and to do so would have to impliedly determine that the property was oversecured. And the congressional record clearly states that determinations on value made in the context of a stay relief motion are not binding on the debtor or the creditor.
Why would you stipulate for the accrual, the continued post-petition accrual of interest if it wasn't oversecured?
Well, I think at the time, the debtor believed that it was oversecured.
And isn't that the crux of it, though? I mean, isn't that what the judge said, is that the parties made a business decision rather than to litigate it and go to the time and expense of that. It was, in effect, almost a settlement that at that time, based upon what the parties believed, and your opponent argues that the foreclosure is not necessarily fair market value, but that you agreed to what fair market value was by allowing the post-petition interest because of 506.
But those determinations of value that are made in the stay relief context are not binding on the debtor.
But this isn't necessarily just stay. There was a lot done in that stipulation. You gave rights to the avoidance. Other matters, this was seen and treated by the court as a more comprehensive endeavor rather than just a mere resolution of a pending stay motion. So are you arguing that that is factually wrong?
I'm not arguing that there was really any factual determinations. It was just looking at the basic terms of the stipulation. And the court addressed another question regarding the determination of value. And I think the court was kind of referring to the Sunny Slope matter where the Ninth Circuit said that a foreclosure value is not the appropriate value, but you should be using a fair market value. But in that case, the court specifically said in the context of a plain confirmation, where the debtor was keeping the property, they shouldn't be using a foreclosure value. But the court also said that the valuation determination should be in light of the proposed disposition or use of the property. And so where the
Let me ask a
post-disposition-
question here, though, because this is the thing that was really confusing me about your argument. You're basically asking the court to engage in a hypothetical valuation analysis after the fact, after the property was sold at foreclosure. Is that what we're supposed to do at confirmation? Once the property's sold, we're supposed to then go back and say, well, at confirmation, it's really would be worth, X dollars, and so you're undersecured. I'm just not sure why we're talking about valuation after the property's been sold.
Well, that's a good question, Your Honor. If the property is sold and it's paid off, then obviously that's not a question. But when the property is sold and there's a deficiency, the question becomes, are they entitled to post-petition interest under 506B? And if the property has been sold and there's a substantial deficiency, then they shouldn't be entitled to post-petition interest. And that is something that sometimes is not known until after the fact. And that's what happened here. Does that answer the court's question on that particular?
Well, I guess I'm not sure what you think the court should have done. You think the court should have hypothetically valued the property after it was sold to determine what the value would be at confirmation? Or are you saying that because it was sold, you get to rewrite your deal and not pay the post-petition interest that you agreed to?
I'm saying that because it was sold at the foreclosure sale and the amount was less than maybe was anticipated it would be sold for, the stay relief stipulation and order doesn't bind the debtor later. That's essentially what the argument is, Your Honor.
Right.
So, counsel, how do we deal with the problem that you never asked for a valuation determination to be made by the bankruptcy court, but after confirmation you argued suddenly that the stipulation wasn't binding when it had never been raised before? You didn't ask for valuation at the time of stay relief. You didn't ask for valuation at the time of confirmation. But then you reject the stay relief stipulation that you agreed to. How is the bankruptcy court supposed to deal with that? Why weren't you required to suggest you didn't agree that this stipulation was binding at some point before confirmation?
So, Your Honor, we actually did bring this up in our plan that was filed after the foreclosure took place. And the treatment or the description of the debt in this particular case, and this is at paragraph 3.01 of the plan, it specifically describes this particular issue and says that the debtor contends that the property is worth, or that the debt is approximately $27 million, as opposed to the $40 million that was contended by Santon. That was in the first plan that was filed after the foreclosure took place. The Santon disputed that, and actually there was a stipulation that was included in the exhibits that ended up allowing the plan to be confirmed, where Santon specifically said, we dispute the amount that the debtor put in as the amount owing by the debtor to Santon in the plan. And we acknowledge, or everybody acknowledges, that there's going to be a separate proceeding to determine the amount of the Santon debt. And FRBP 3012B is very clear that that determination can be made in the context of a claim objection. It doesn't have to be made in the context of a motion of value or some other plan context. And so that's
But it's required for confirmation.
I'm sorry, the plan valuation is required for confirmation?
The valuation, yeah.
So not necessarily when it's determining the amount of the claim. And that's what was happening here. We were determining the amount of the claim. All the parties understood that we were going to have a future proceeding. And there's actually a stipulation that is in the record. This is at...
Yeah, we're familiar with the stipulation.
Okay, so it's number 23, but it's number 2. It says Santon contests the amount of its claim stated in paragraph 3.01 of the plan, but understands that the plan does not fix the amount of its claim and that there will be a separate proceeding to determine the correct amount of Santon's claim. So that was understood as of the time of the confirmation. Everyone understood there's going to be a separate proceeding. The plan stated what the two different amounts were, and there was an understanding that there was going to be a determination that we're going to argue this specific issue.
All of that is after the fact of the relief from stay. So, I mean, you're using these subsequent acts to modify the effect of the relief from stay. And I understand that the parties said we'll get that specific issue before the court later by the objection. But it still requires us to examine what the effect of the relief from stay was at the time the court entered its order, doesn't it?
I think that's correct, and I think the court should be looking to the congressional record where it interprets Section 506 to have an understanding that determinations made early in the case in the context of adequate protection or stay relief matters are not binding on the parties later in the case, especially claim confirmation or claim objection matters that have come up later in the case. So I see that I've run to my rebuttal time. If the court has any more questions, I'd be happy to answer them now, or I can reserve the balance of my time.
You can reserve.
Thank you very much.
Thank you.
All right, Mr. Kinsey?
Yes, may it please the court, John Kinsey appearing on behalf of Appellee Santon Credit Solutions, Master Fund 4 LP. We agree that the stipulation and the subsequent order essentially reflect an agreement akin to a settlement between Santon and Sloane regarding the valuation and allowance of post-petition interest.
So then why did you agree to a player to be named later, a hearing later for the amount of your claim? Because based on the first stipulation, the plan was required to incorporate the terms of that stipulation. That was the agreement. And yet they filed a plan that didn't incorporate the terms of the stipulation because it had a lower amount. So why did your client agree to a subsequent proceeding for the claim determination?
Well, we understood, Your Honor, that there would be an objection to the claim. That being said, it was a settlement, and that was the mechanism that
there was never a 9019 motion, though, was there?
There was not, and there was also not there was no motion to value the claim, so there was simply a claim objection. Right,
but taking the contra is that it comes on a relief from stay. It's an order and stipulation resolving relief from stay. So, is it proper to treat it as a settlement?
Well, Your Honor, the stipulation was more than simply a recital or a preamble of those amounts.
But if it was, then shouldn't it have been brought as a 9019? I mean, you're transferring avoidance actions.
We don't believe that's the case, Your Honor. This really was akin to an agreement, and the debtor agreed that those debts were unconditionally and absolutely owed, and as a result of that, in the adjudication of the objection to the claim, we believe that the court did not commit clear error in that regard in light of the prior agreement that those amounts were unconditionally and absolutely owed.
So counsel, in agreeing that you would not object to the plan and that the plan could be confirmed, what were you giving up if you already had believed that your claim had been determined and that there wasn't going to be a subsequent determination of your claim? What did the debtor get out of the agreement, the stipulation at confirmation?
Oh, quite a bit, Your Honor, and Santon obviously changed its position relatively significantly. This wasn't just resolving two motions for relief from stay. It provided Sloane 4 additional months to market the properties. Sloane avoided a contested.
No, I'm sorry, counsel. What I'm referring to is the stipulation that you had at confirmation that the plan could be confirmed and that the claim would be adjudicated later if there was no real agreement to adjudicate the claim later, because pursuant to the stipulation that had previously been entered, you believe the claim had been resolved. What did the debtor get at that confirmation by your agreement to let the plan be confirmed?
Yes, I mean the debtor did get to have the plan confirmed subject to the resolution of this issue.
But there was going to be no resolution of this issue according to your prior stipulation. As you interpret it, it's binding, and so that you didn't give up anything at that point, did you?
That's correct, Your Honor.
Okay.
We did not intend to waive any argument there. That was very clear in the discussions between the parties, and the court also acknowledged that. And so I think from our perspective, this is an easy issue. This was a settlement. The amount of the debts were unconditionally and absolutely owed.
Again, I'm troubled by that because bankruptcy rules specifically address settlements, and it is clear that the stipulation does go beyond relief from stay. It affects the discharge. It affects the avoidance. You transferred avoidance actions, but it is within the guise of relief from stay. So why? How is that proper?
It's proper, Your Honor. I mean, ultimately, Santon, this wasn't, again, just resolving a relief from stay. This was avoiding a contested confirmation hearing. It was avoiding a 2-day
But again,
trial.
that's the problem. There's no through line. There's no straight line through it because, Judge Brown was right. It expressly concludes with the plan of reorganization shall be amended and include treatment of Stanton consistent with the foregoing, and it's not, and you didn't object. I mean, that wasn't really. Shouldn't that have been resolved at confirmation? I mean, wasn't that really the off ramp to get this decided one way or another?
Well, the parties ultimately agreed via stipulation to resolve it as we did. And that was to avoid, obviously, a lengthier contested hearing. So we don't see that there was anything necessarily that would have required us to object to the plan, as opposed to stipulating to resolve it in the manner that we did. And again, regardless of this issue, it was still incumbent upon the debtor to attempt to affix the valuation of whether the debt was oversecured or undersecured via.
Where does the relief from stay stipulation establish the value? Because crediting opposing counsel, it establishes debt.
That's correct, but it also establishes the debt, and it does so in an unconditional and absolute way, and that debt included post-petition interest.
So you're saying there's at least an implicit understanding that your claim was oversecured because post-petition interest was provided for in the stipulation, right?
And that's correct, and it's borne out by the procedural posture of the case at the time the stipulation was entered into.
There was no specific agreement as to value. It's just more than the debt because post-petition interest accrued.
That's correct, and if the debtors did want to contest that issue, it was incumbent upon them to file a 506A motion. So that was the debt.
Well, they could have done it through confirmation, or they could have done it through the claim objection too, right?
Correct, but under neither instance did they do that.
So, counsel, if at confirmation they had suggested that they wanted a valuation under 506, wouldn't you have opposed that on the basis that the claim has already been determined? It's already been determined to be oversecured. It doesn't matter to what extent it is. You're still oversecured and entitled to interest, as set forth in the prior stipulation.
Yes, if that relief had been sought, that would have been our position. And I think that obviously the stipulation bears that out.
So why doesn't that run into the problem that Santon is suggesting? I'm sorry, that Sloane is suggesting, which is that a stipulation as to value at a pre-confirmation hearing, such as stay relief, isn't binding. Why isn't that a problem for you?
Your Honor, in every instance where that's been pointed out to us in the briefing by the debtor, it's been a completely different procedural posture, and more importantly, there hasn't been an agreement, a stipulation to the actual amount of the debt in those cases. Here, there was a stipulation that made that unconditional and absolutely owed, that was agreed upon by both parties. Santon relied upon it and very substantially changed its position as a result of that.
Do you agree that absent the stipulation, the foreclosure would have set the value for your claim at confirmation?
The value of the claim, or the value, or the
value of the secured claim?
No, Your Honor. The case law. This was just this was a foreclosure credit bid. That's not the value with respect to whether a claim is oversecured or undersecured. That's typically the replacement value for the debtor. And
but isn't that when the property is still owned? What about the situation where we have here when the property is gone? Would you have, if you, in the absence of the stipulation, there's a foreclosure, would you then have had a confirmation to determine the market value? A valuation here to determine the market value of this property that was foreclosed?
Well, I think that would be a much different context than what we have here. Here we had a resolution, before any of that occurred, a resolution that was agreed upon prior to the properties being sold.
Well, let's play the what-if game then, right? Because the stipulation was December 2020, confirmation was 2022, so 14 months. Okay, I get 14 months. Say it's 3 years, and the market changed. Are you saying that stipulation would have bound the confirmation determination 3 years later?
Yes, Your Honor. I mean, that was an agreement, and here there was no.
But again, that agreement is within the context of what has to be done, which is the valuation at confirmation.
Right, but here but here again, there was no request for relief from that order. There was no.
Why doesn't the order say that? I guess to the nub of it. Seems like we could avoid a lot of time and expense if the parties had been explicit as to what that was going to do, rather than resolving just the relief from stay motion, which is a procedural motion. I mean, if the parties had been clear one way or another, that would have avoided a lot of time and effort. Don't we take that into consideration here? I mean, it kind of gets into almost a question of ambiguity.
Well, I will say, Your Honor, that the stipulation that we're talking about here did include a clause that the court retain jurisdiction to interpret the stipulation.
On relief from stay. There's no question about relief from stay.
But the stipulation went far beyond.
But the procedural aspect was relief from stay. It was not a 9019. It was brought within the context of a relief from stay, and notice to the world, such as it was, limited as it was relief from stay.
And Your Honor, I agree that the context of the stipulation was in the context of relief from stay, but the consideration that was provided within that stipulation and within the order, did go beyond that. And the relief that Santon did provide to the debtor also likewise went beyond that. And the court ultimately retained the jurisdiction to interpret that stipulation. And in light of the circumstances, in light of what Santon gave up, I don't think that factually it would be appropriate to find that what the court did in this instance, in light of that stipulation, in light of Santon's change in position, constituted a clearly erroneous decision. So in sum, we believe that the stipulation here was quite clear. It was unconditional, absolutely owed. To the extent there is an issue regarding valuation, there was no motion filed under 506A. And finally, as articulated in our papers, this truly is an instance where judicial estoppel should apply because of Santon's very dramatic change in position as a result of the stipulation. And with that, Your Honor, I'd be happy to answer any questions that you might have.
Any more questions?
I don't.
Okay, thank you. All right. Mr. Fear, you've got a little bit more than 4 minutes.
Thank you. So one of the questions that continued to come up in the last argument was, why was there no 9019 motion filed? And I think that's actually a really good question to be asked, because that demonstrates that there wasn't really an intention to settle the 506B issue. It was intended to be just granting stay relief. And there's another thing that counsel for Santon argued, was that there's a substantial change of position. I don't think that that's really a fair characterization of what happened here, because Santon got relief from stay 3.5 months after the stipulation was signed. So they actually got relief from stay. They actually did foreclose. They got what they were asking for. They just took them a little bit longer. The litigation that was leading up to the December 9th stipulation had actually taken about 10 months to get to that place. It was pretty hotly litigated. So they got stay relief, but it was just a little bit after it. There wasn't a substantial change in position. So I don't know if the court has any further questions for me. I don't have any further argument beyond what I've made so far.
I don't. Anything?
Well, counsel, I just have one question, which is,
Sure.
it's appeared that from the record that your client believed the property had $200 million worth of value with regard to certain water rights. And so they never believed, evidently, that the stay relief would ever be, actually, the foreclosure would occur, but there would be a sale, and the sale would be in excess of whatever was owed to Santon. That didn't happen. But that's the gamble that you took, didn't you, when you entered into this, was that you believed that this was all not going to be adverse to your client, and that was a gamble that you lost, evidently.
That is correct as to the stay relief question. That's what my client believed at the time and was arguing at the time. That ended up being incorrect, as can be seen from the foreclosure values that were achieved. If the properties actually had that amount of value, they wouldn't have sold at the foreclosure sale for a total of $30 million. So, and I think that the foreclosure sale values or prices are precisely the values that this court should be using or that any court should be using in determining what the value of the collateral was, because that's what actually happened. So, yes, my client did think that, but my client was wrong. The stay relief stipulation and order are not binding on the debtor or the creditor later. And so because of that, we believe the lower court should be reversed and this remanded to the lower court. Any further questions?
No, thank you.
No,
Thank you for your argument.
Thank you very much.
All right, the matter will be submitted.